Ladies and gentlemen, hit subscribe to this channel right now. This is the most important story, and we'll be talking about this for years and decades to come. Hit subscribe to this channel. This is Vanity Fair from several days back. Trump is looking for a little help from his friends on the Supreme Court after historic conviction. The reason that this article and others in Vox and Axios and other publications, liberal publications, are telling their audience, preparing their readership for a historic overturning and reversal of an unconstitutional guilty verdict. I told everyone on this channel and hit subscribe that there would be a 9-0 unanimous Supreme Court decision overturning the Colorado ban. There was. Now I'm telling you, you can type in Supreme Court guilty conviction Trump or Supreme Court jail sentence Trump, and you will get articles talking about, well, the Supreme Court might overturn this conviction. Most people are not really focusing on the conviction being reversed or overturned on constitutional grounds. I am telling you, ladies and gentlemen, and you will hear exactly why. Tony, D'Artagnan, hello. Everybody here, hello. Hudson, hello. To my super chat, by the way, thank you below. If you want to support my work long term, my Patreon is below. And to the members, thank you. God bless you all. Hit subscribe. Vanity Fair article, Trump is looking for a little help from his friends on the Supreme Court. That is because it's going to happen 100%. I guarantee the Supreme Court will overturn this absurd conviction. I cannot tell you, though, when it'll happen. It should happen before sentencing. I guarantee either the appeals court or the Supreme Court will overturn the unconstitutional guilty verdict. You cannot have, and this is why they'll overturn it, it's just like the Colorado ban. You cannot have, and we'll hear from former FEC chairman, you cannot have, and legal scholars, you cannot have a federal statute leveled at Trump by any state, including New York, if the federal government, the FEC, the IRS, and the DOJ were not involved. There is literally no federal statute that the New York court used to convict Trump. Nobody is able to find the specific statute. And he did not commit a federal crime because the DOJ, the Department of Justice, didn't level a federal crime at him. The state of New York did. That is unconstitutional. It's so blatant and overt. Hit subscribe right now. We'll start with the Supreme Court overturning unanimously, even the liberal justices, and then we'll get to legal scholars explaining it's already taken place. So, ladies and gentlemen, when Vanity Fair and Vox and others are preparing their readership for Trump's guilty verdict being overturned, I'm the only person, really the only person, perhaps in all of YouTube, explaining that it's already essentially been overturned by the Supreme Court precedent. Each of these Supreme Court justices, even the liberal ones, know a federal statute cannot be leveled at Trump at the state level without the federal government involved. Hit subscribe. Check this out. I told everyone this would happen, and then I'm telling everyone it will be overturned 100%. I cannot tell you, though, when. Should be before July 11th. Definitely, I think it'll be before November 5th, and he'll get the immunity victory as well. Two major victories, huge Second Amendment victory the other day. Check this out.
Now we roll it, folks. This now is a Fox News alert, and reading this. The U.S. Supreme Court rules in favor of former President Donald Trump in his appeal of a Colorado ballot disqualification. That applies to Colorado. In all likelihood, it will apply to other states as well. Live to Shannon Bream for her initial analysis and reaction now.
This is exactly why you should hit subscribe to this channel. This is exactly why the conviction in New York will be overturned. You cannot affect a state, whether it's Colorado or New York. It is unconstitutional for a state ruling to impact the entire country, which is exactly what happened in New York. A federal statute was leveled against Trump, but not by the federal government. And a federal statute was leveled by the Colorado Supreme Court, but not by the federal government. And that's exactly why the liberal justices, and I think liberal justices will side with Trump on overturning the conviction. And I also think that he's going to get a huge immunity victory, 2 major victories. This is March Madness for the Constitution in June.
You have the inside word, Shannon. Hello.
Okay. So what we have from the court this morning is this decision in favor of President Trump. They essentially say the judgment of the Colorado Supreme Court that he could be kicked off the ballot in this manner does not stand, has to be overturned. Now, it's a per curiam opinion, which the Latin for that is sort of the court speaks. It's supposed to be sort of a unified voice. But we do, as I'm looking through here, have some additional folks who wrote, Justice Barrett, and I believe Justices Sotomayor, Kagan, and Jackson. They write concurrences as well. So they may have gotten to this in a different way, but I don't see any dissents here. So it sounds like the court as a whole is agreed that whatever happened with Colorado, it was not the proper framework to use here. There is discussion at the end of the main decision that says, you know, there would be essentially a patchwork across the states. This was one of the worries that the justices had, and the questions that came together in argument were, what happens if we tell one state they can do this? The Chief Justice said, what if one state decides, okay, I'm kicking off a Republican, another state says, okay, I'm kicking off a Democrat, and then we get down to just a handful of states that actually have all of the candidates' names on the ballot. What would that do to this country? So it sounds like the majority of the court has come together in this voice to say what happened in Colorado is not correct. It sounds like they're saying states don't have this power, but essentially this is something that should be left to Congress.
The Supreme Court has already overturned Trump's conviction, essentially with this unanimous decision to overturn the Colorado ban. You cannot convict Trump of a federal crime at the state level when there's no federal crime or statute that the federal government leveled against Trump. This is basic civics. A state court cannot convict any citizen of a federal crime without a federal statute leveled, in this case, by the Federal Election Commission. And you'll hear that in a moment.
And so they agreed to that point, but how they got to these different positions, how they got to the agreement, they found some different maps there, but they got to the same end result, guys.
So, Shannon, I have 2 questions for you. One is about Sotomayor. She was considered to be somebody who might disagree. And also, does this mean that for any other state that is thinking about this, like Illinois, for example, that if they're thinking of trying to keep Trump off the ballot, that they would be barred from doing so based on this decision?
Yeah, what I've seen so far of this and trying to read through here, it sounds like what they're saying is the states don't have this power. So that would mean any state, essentially saying this is something that should have been left to Congress. If you're going to, you know, there's questions, not to get too wonky, but about the 14th Amendment, if it was self-executing, if states could pick it up and say, we find someone we think was guilty of insurrection, and so we're saying they can't be on our ballot. There was question, though, whether Congress has to give some framework for actually kicking someone off the ballot or making a decision about kicking someone off the ballot. So it sounds like here, they say the disruption to allow states would be acute, could nullify the votes of millions and change the election result at different times. They say enforcing Section 3 against federal office holders and candidates rests with Congress and not the states. So the
enforcing federal election law rests with the Federal Election Commission, not with the state of New York, the state of Colorado. So when I tell you that it already happened, it essentially already happened. This is just a matter of timing now. I cannot tell you when. I told you it would be unanimous. That's why the channel is growing, because I've been spot on. I'm not Nostradamus, but I've been spot on, ladies and gentlemen. And this is the most important story in American politics right now. We know Trump's going to win a landslide. He's going to win, could potentially, I think very likely be a landslide. If he's doing well in Minnesota and he's only down 10, 12, 13 points in New York, he's not going to win New York. He could very well win Minnesota. He's going to win in what I think is a landslide. And that's because Biden and Democrats have such a utterly failed, miserably failed foreign policy, and economic policy is a catastrophe. We have inflation and interest rates, and then they say, well, unemployment's low. Yeah, but real wages are affected by interest rates, by inflation. And inflation is around 3.5% because interest rates mortgage rates are close to 7% or over 7%. for a 30-year fixed, I think. Okay, you're paying double for your mortgage if you bought a house under Biden than you did under Trump. You'd have to be a complete fool in terms of financial knowledge not to vote for Trump and just to vote for the current occupant, mashed potato brains. He depleted strategic petroleum reserves to artificially lower the price of oil, which then helped lower inflation, while at the same time his Fed raised interest rates. And it's like we're on thin ice in terms of, I mean, we're looking at a major crypto crash in the coming months, and stock market crash. And so you have $1 trillion in credit card debt, more than that, record highs in credit card debt fueling consumer spending, and then they say the economy is good. Anyway, hit subscribe. Let's continue.
So the judgment of the Colorado Supreme Court cannot stand. That sounds like a clear message without having read the entire opinion, but a clear message that states do not have the power to do this.
Yes. We'll allow you a moment to get a few paragraphs into your big brain, Shannon. Let's move to our team now. Jonathan Turley, you are first up to react to this now, sir. How do you hear it?
Well, I've just been reading the opinion. It's obviously sweeping. There aren't any real dissents, so it does look like it is unanimous, at least on the result. What they have a disagreement on is whether the court had to go as far as it did. Now, the most practical result of this is that the voters will be able to vote for the candidate that they prefer. This was a critical moment for this court in history. After all of the years we have spent in this republic, we came to a point where these states claimed that they could unilaterally bar the leading presidential candidate from ballots to prevent people from voting for Donald Trump. The court here spoke with a strong, and it appears unanimous voice, at least on the result, that that's not going to happen, that voters will vote. They'll make their own verdict, regardless of what happens in cases involving President Trump. They will cast the most important verdict of all. They will vote for the next president of the United States.
Okay, stand by there, sir. Let's get another opinion in here. Andy McCarthy.
So you can look, ladies and gentlemen. It's right here, Vanity Fair. Trump is looking for help from his friend, the Supreme Court. They already know what's taking place. Every liberal publication, popular, political, generally liberal publication with liberal leaning, is preparing readership for the eventuality. The guilty verdict is going to be overturned for the following reasons. Right here. It's not legally valid.
Question mark. The Manhattan DA says he will not appear on Capitol Hill today as House Republicans hold a hearing on former President Trump's New York trial. Bragg citing scheduling conflicts. He is set to testify, though, on July 12th, just one day after Trump's sentencing. Federal Election Commissioner Trey Traynor and Missouri Attorney General Andrew Bailey set to testify today at today's hearing, and they join me now. Trey, you notice I emphasized the election in your title. I guess we're finally set to hear from somebody who actually understands how election law works. Juan Merchan cannot silence you. What are the top points, Trey, you're going to try and drive home today?
Well, the most important point is that Judge Merchan completely obliterated what's been longstanding federal election law with the jury charge that he gave, asking the jury whether Donald Trump had willfully contributed to a campaign. And the legal standard has long been knowing and willful standard, so he's completely upended that standard. And it's one of those things where the Department of Justice should have intervened early in this case and protected the jurisdiction of the federal government to enforce federal campaign finance law. They didn't. They didn't protect the jurisdiction of the Federal Election Commission. And it's completely perplexing why they didn't do that. There's long-standing Supreme Court precedent that says that they should have.
And it's just how law works. People always fight over jurisdiction. They never give that up. And in this case, it was ceded so easily. Andrew, Democrats, of course, are going to try and flip the script, calling today's hearing playing politics. And they're going to make this point, Andrew, A.G. Bailey.
The state of New York has no jurisdiction over federal election laws. They cannot unilaterally, just like Colorado cannot unilaterally decide Trump committed a federal crime without Trump having been accused of a federal crime. This is blatantly unconstitutional. The Supreme Court has already overturned this based on precedent and based on what I believe each of the justices looking at the absurd verdict have thought to themselves, even the liberal justices. You could get a unanimous Supreme Court decision overturning the state verdict. Now, I don't know when it'll happen, though. It should I mean, there's a chance, 2%, 5%, that Trump actually goes to jail, which would then, his conviction would be overturned, but that could expedite, or there's a chance that they could sentence him to jail, and then that would actually expedite the Supreme Court stating it was unconstitutional, which, of course, Democrats who care so much about Trump being an authoritarian would then condemn. And it's funny, they are petrified of Trump being this despot and tyrant, while simultaneously disparaging and demeaning and trying to, insult the Supreme Court. The Supreme Court is tasked with deciding what is constitutional and what isn't constitutional. It's the antithesis of an authoritarian system.
They merely follow the facts and the law up there in New York City. How will you cut the legs out from under that argument?
Well, they bent the law to meet the facts in a specious legal charge. There's an unseemly amount of prosecutorial misconduct. And at the end of the day, what that does is it injects both statutory and constitutional violations into the process from the charging document onto the jury deliberations. And so this is a legally errant conviction. It's not a legally valid conviction. And that emphasizes the illicit nature of the witch hunt prosecution. And it's important that the American people understand that the goal here was never to convict President Trump of a crime. It was always to remove him from the campaign trail. Now, this is a presidential candidate that has a right to speak and that we as a people have a right to access. This has done immeasurable damage to our democratic republic, and we've got to hold wrongdoers accountable.
Let's focus on this Matthew Colangelo, Alvin Bragg dichotomy here at A.G. Bailey, because the number
It's not legally valid. It's unconstitutional. It's blatantly unconstitutional. That's why I'm focusing on this, because everyone should be talking about this throughout the country. Everyone should be talking about this throughout the United States of America. Randy, thank you. Randy Duenas, thank you. Shabbat Shalom, Randy, thank you. J-Spot. Oh, God forbid, God forbid. J-Spot, thank you. J-Spot, thank you. Randy, Shabbat Shalom, thank you so very, very much.
3 starter right now in the Yankees rotation is not waving his hand and saying, please send me to single A so I can ply my craft. What possible reason could Matthew Colangelo, the number 3 at the Department of Justice, have to leave the DOJ, go down to the Manhattan DA, if not for his desire to help the Democrats and get Trump?
Yeah, the DOJ may not have intervened to reassert the jurisdiction of the FEC. That's the appropriate legal avenue for the DOJ. But instead, what they did was deploy resources to the state of New York in the form of Matthew Colangelo, like you said, the former third-ranking official in Biden's Department of Justice, who led the trial court prosecution against President Trump on behalf of Alvin Bragg. So he takes a pay cut to go work in state court. He's politically motivated. Those prosecutors should have been disqualified from prosecuting that case. There was no case to begin with. A subsequent prosecutor that the court could have appointed would have identified that and dismissed it before it got this far. And again, Biden is behind this whole thing. I mean, he has managed the Department of Justice that also administers grants on behalf of the Soros-backed Vera Institute to Alvin Bragg's office with the intent of dismantling the criminal justice system. So while Alvin Bragg is ignoring crime in the subways and on the city streets, he is being trained to weaponize the criminal justice system against Biden's political opponents.
Trey, quick final word to you. If we don't stop this lawfare right now in its tracks, can our
Not only is Merrick Garland held in contempt for withholding audio, the tapes of the interview of Biden and his special counsel, because obviously you have somebody murmuring and stumbling about and speaking in an incoherent, hushed, slurred tone, probably most of the time, and lying through his teeth. The Democrats care so much about lying and Trump's lies, yet Trump doesn't lie about things like a laptop full of bribery and graft. you'd have to be a complete fool not to understand that 50 intelligence officials actually came out of nowhere to lie about Biden's laptop because there's almost certainly criminal activity there, and they're going to bat for the establishment. And then they say Trump is the authoritarian. It's like you couldn't get a greater example of tyrants and despots than trying to ban Trump nationally in Colorado and having it then overturned by the United States Supreme Court. Then he's convicted of something that wasn't a crime. The FEC and the DOJ dropped the case, the hush money case. They already looked at it. They said there was no crime. They actually fined Clinton and the DNC. They committed the crime, or the civil crime. They violated the FEC, Federal Election Commission statutes, for purchasing the Steele dossier, another despotic move by Democrats who wanted to create a new fabricated Cold War. So they accused Trump of things he didn't do in a dossier literally purchased by a foreign intelligence official. But let's continue.
Century-old justice system survive?
No, it can't. And we have a big threat to the First Amendment and whether or not candidates can actually run for office in any state, because we'll have turned loose all the prosecutors across the country, whether they be state or local prosecutors, to go after individual candidates for perceived violations of campaign finance law.
Thank you for what you're about to do on Capitol Hill.
This is a perceived violation of campaign finance law. That's why Vanity Fair, that's why Vox, that's why all these publications, Trump is looking for help regarding his historic conviction. Can the Supreme Court nullify Trump's conviction? And then everyone says, from Vanity Fair to Vox, there's no constitutional grounds. Well, yes, there is. There are constitutional grounds. He did not commit an FEC violation or even a crime. And we have Trey Traynor, who was the FEC chairman, and we now have Bradley Smith stating the same thing. And we have Hans A. von Spakovsky, another FEC chairman, stating he did not commit. Trump categorically, and neither did Michael Cohen, who committed other crimes, literally committed other crimes. Like Michael Cohen, Hunter, these people actually committed crimes. Trump did not, and then he gets convicted, of course. But listen to Bradley Smith stating categorically what Trump did was not a crime. It was completely legal. And it wasn't a federal crime. That's why the FEC dropped.
So Trump's indictment looks like a perversion of campaign finance law. There are no crimes committed, or at least that's what Bradley Smith, Capital University law professor, chairman, and founder of the Institute for Free Speech. Mr. Smith is a former FEC commissioner, and he's the co-author of Voting Rights and Election Law. Brad, you're writing in the Wall Street Journal. We've been trying to get our paws on you for the show. Thank you for coming on. You're saying there was no crime.
My pleasure.
There was no crime to start with. Even if there were some issues on the so-called filing of business papers, there was still no crime.
Right. I've had a bit more time. I had the commercial break to look at the indictment a bit more. And it looks like the last couple pages of the indictment do intend to say that the crime was not disclosing campaign contributions, although they never cite a specific government statute. But here's the problem here. The prosecutor's theory goes like this. Federal law says it's a campaign contribution to make an expenditure for the purpose of influencing a federal election. Those are the key words, for the purpose of influencing. And he says, well, these payments were intended to keep her quiet, which would help the campaign, so they were for the purpose of influencing the campaign. Now, first, these payments could have been made for other reasons, right? To prevent embarrassment to his family, to preserve marital harmony, all kinds of things. But none of that really matters, because the standard here for the purpose of influencing is not a subjective standard, it's an objective one. So if I go out and I want to pay for TV ads that say, Donald Trump is a ding-dong daddy from Dumas Bay, because I think that's really going to help him win re-election, it doesn't matter. Legally, that will not be for the purpose of influencing an election, no matter what my own subjective purpose was, right? It's subjective. So what counts as campaign expenditures? Things like, you don't hire a campaign manager unless you're running for office. Right. You don't take out ads saying vote for me unless you're running for office. You don't hire or establish field offices unless you're running for office. But other things you do. For example, you buy clothes, whether you're running for office or not. So the fact that I'm running for office and I say, I've got to look good, and I go out and I buy a $6,000 suit that I would never otherwise buy, doesn't make it a campaign expenditure. It doesn't count. Same if I say I need a $600 haircut. Or to take a more perhaps relevant example, suppose I'm a business owner and I say I'm going to run for office, and I go to my corporate lawyer and I say, there's some lawsuits against our corporation. I think they're bogus, but let's get rid of them so they don't interfere with my run. Just settle those lawsuits. You can't settle those with campaign funds. It's not a campaign expense, even though that person's subjective purpose was to influence the campaign.
By the way,
so that's a very important part of the law.
I know. I was very impressed with the $6,000 suit. That must have been a custom bespoke suit. In your op-ed piece, it was $4,000. But I know we've had an inflation problem in the last couple of weeks. But your point here, I'm just having some fun. But your point here, Brad, if I understand it, is that you buy a suit, you get a nice haircut, whatever. You're doing it directly for the campaign. Is that correct? That's the point you're making. But if you want to
the point is, yeah.
If you want to defend yourself, your honor, keep it away from your wife, that kind of thing, which, by the way, is unproven. I mean, Stormy Daniels keeps telling people she didn't have an affair. Nobody wants to listen to her, but that's perhaps grist for another segment. But if that does not qualify because it's not directly for the campaign. Is that right? Is that my correct interpretation?
It actually goes further than that. Even though you bought that suit because you were running for office and want it to look good, it's still not a campaign expenditure.
Oh.
Why? Because you buy clothes. You buy clothes whether you're running for office or not.
But you don't buy a Steele dossier full of lies with campaign money. Bernie Sanders was cheated in a completely absurd, theatrical performance called the DNC primary, where everything is just, that's why Hollywood loves the Democratic Party. They're all actors and producers and directors, and it's not what you see. The people who accuse Trump of lying lie all the time in numerous ways. They're all actors, and there is no actual primary. That's why Debbie Wasserman Schultz, the wonderful chairwoman of the Democratic National Committee, resigned. That's why when people say, you said Bernie Sanders would win, and it's like, well, I wish I'd written all that about Trump and not Bernie Sanders. I was the biggest Bernie Sanders booster on the internet, according to the Huffington Post, and the unofficial scribe of Sanders' most hardcore voters, according to the Washington Post. I wish I had spent all that energy in The Hill, the Huffington Post, Salon, and other publications, writing, about how Trump would be an amazing president. We had record low poverty, record highs in household median income, without inflation and without interest rates and without a catastrophe in terms of foreign policy. He was a great president. Objectively, Trump was a great president, but Democrats purchased a Steele dossier only for 2016. They actually broke campaign finance laws, and it's Trump that they want to jail for campaign finance laws. Again, there is a possibility he does go to jail. They want to jail him. Trump might be fine with that. God bless him. It would be overturned immediately within the Supreme Court. That might be the only way to expedite the Supreme Court ruling on it. I do not know. I know with certainty, I guarantee and I know with certainty that the Supreme Court, when it gets the guilty verdict, they look at it, they'll see it as unconstitutional because a state cannot level a federal crime without a federal statute and without the FEC involved. I don't know when. I'm telling you, ladies and gentlemen, okay, I don't know when the Supreme Court will get involved. There's like a 2% chance it's after November 5th. And Trump would still win. But the point is, they have to get involved before November 5th. We'll get to that in a moment.
Right. And so anything that people might do, even if they're not running for office, doesn't count. So people pay money. For example, they pay divorce attorneys to try to seal up their divorce records so that those don't become an embarrassment of the campaign.
Right.
Their purpose may be to influence the campaign, but it's an expenditure that somebody who wasn't running for office might also make. The only things that count are things that come directly out of the fact that you're campaigning. And the flip side of this is that it's actually illegal to convert your campaign funds then to personal use. So it's actually illegal to use your campaign funds to buy that suit. It's illegal to use your campaign funds to pay a lawyer to seal your divorce records because you think that will help your campaign. And this is the real problem you have here. Not only is there, I think, not a campaign finance violation, this underlying alleged violation, but it's a situation where they're going to get Trump coming or going, because I think, knowing Bragg, and you've set the political stage very well, had Trump paid for this with campaign funds, I think we can feel pretty certain that he would be being charged today with having illegally converted his campaign funds to personal use. In other words, they were going to get him coming or going. If he pays for it with campaign funds, they were going to say it was illegal personal use. If he doesn't pay this money with campaign funds, which was the reality, now they say, oh, well, he should have used campaign funds. And that's, you know, the antithesis of the rule of law, where you set up a system where no matter what course of action a person takes, they're going to be held in violation of the law.
Well,
Alan, thank you so much. Alan, to my super chat. Thank you. Everybody here. Anthony, hello. Everyone, hello. Alan, thank you so very much for the super chat. Greatly, greatly appreciated. Yeah, it's so important. And he didn't use campaign funds. My God, had he used money donated to his campaign to pay off Stormy, I wouldn't vote for Trump if he had a laptop full of bribery and graft. I wouldn't vote for Trump if he had private servers with illegally transferred top secret intelligence on them. I wouldn't vote for Trump if we had wars and military conflict, high inflation, high interest rates, if he depleted strategic petroleum reserves, if he was like doddering and stumbling about and slurring his speech and muttering incoherently. But I'm not a Democrat. Actually, it's like they keep you there forever. I was a lifelong Democrat, and they wouldn't let me not be a Democrat anymore. I said I want to just be independent. Then I get a letter saying, oh, you know, we can't, we couldn't. It was from the DMV. It was like we can't, we couldn't process your request. I'm like, gee, I wonder why. Let's continue.
well, I mean, but how does that get up to the federal election?
But I'm definitely just gonna put in, like, make sure independent, no political party.
Commission, which has already turned this case down once.
Right. Well, this raises yet another question: is can, of course, a state prosecutor prosecute an alleged, quote, federal crime that the Federal Election Commission and the Department of Justice have already decided not to prosecute? We might think.
This is gold, ladies and gentlemen, absolute gold, right here.
Of course, a state prosecutor of the rule of law, say it was illegal. You set the political rule of law where.
Commission, which has already turned this case down once.
Right. Well, this raises yet another question: is can, of course, a state prosecutor prosecute an alleged, quote, federal crime that the Federal Election Commission and the Department of Justice have already decided not to prosecute? We might think about it this way: imagine if New York just passed a law saying it is a violation of the New York Penal Code to violate any federal law. And then we'll decide what federal law is violated, right? That would subvert the entire federal state structure of law. I mean, that would allow state DAs to start prosecuting anything they think is a violation of federal law, even though the federal courts or federal administrative agencies or the Department of Justice had felt it was not a violation of federal law. So it's really getting into sort of wacky legal theories, but also I think very dangerous theories. Again, if we think about the rule of law, I don't think this can be emphasized enough that if Trump had paid for these with campaign funds, which the DA says he had to have done, I think they'd probably be chasing him today for illegal conversion of campaign funds to pay this personal expense.
We don't know.
So he explained it brilliantly, Bradley Smith. You cannot, and this is why they're already writing these articles, ladies and gentlemen. You cannot use You cannot have a state decide what Federal Election Commission laws somebody broke without the FEC involved. It is not constitutional. It is the biggest, most important story in American politics now. It is, I'm at the forefront of this, because of you, ladies and gentlemen. I thank God that, I have a viewership and that everyone from around the country, from the U.S., around the world, God bless you. Thank you for watching in Canada, the U.K., Australia, the Philippines. New Zealand, everywhere around the world. Korea, thank you so very much. Nigeria, if you're watching, thank you so much. This is Mark Levin. Around the world, thank you for watching. God bless you. Mexico, God bless you. Thank you for watching. And I'm just very blessed and honored to have people listening to my analysis. I'm very thankful. And be here November 5th. November 5th is going to be one of the most beautiful, wonderful, amazing, awesome, historic days in American history. Donald Trump, and God bless him, will win again despite overwhelming challenges, advantages that Democrats have over him. And it's that'll prove that virtually all of media serving as a mouthpiece for the Democratic Party cannot control the future of this country. They were successful 4 years ago, but long term, Trump's coming back, and it's going to be a beautiful thing. We're going to, with Trump, don't worry, wonderful, morally superior liberal Democrats. We'll have a great economy and a great foreign policy. And of course, they'll melt down, but the country will do better. Okay, if Biden did a great job, I'd vote for Biden. But he's doing an categorically abysmal, without a shadow of a doubt, terrible job. Okay? Hit subscribe. This is Mark Levin talking about how we get it to the Supreme Court.
To say that's enough. Your deadline has been met, and that's the end of it in Florida is far more extraordinary. Far more extraordinary than anything Donald Trump and his lawyers would be asking the Supreme Court to do. Why? These are federal law, federal constitutional violations, federal jurisdictional violations.
Mark Levin is brilliant. He's a brilliant man. And these are federal jurisdictional violations. The state of New York, and hit subscribe. This is why you watch the channel and why you watch endless coverage of the same story, because it's so important. It's the most important political story today and one of the most important in American history. The state of New York does not have the jurisdiction. They don't have the authority under the Constitution to level a federal crime at Trump. End of story. Game, set, match. 100% guaranteed it's overturned by the Supreme Court. Basically already is, based on the Colorado precedent. But we have to, I don't know when the Supreme Court will get it, hopefully before July 11th.
By an acting state judge and a prosecutor by two people. And it's ongoing. Sentencing and other issues have to be decided by the local judge, and then the appellate level, and then the level after that. This is an ongoing violation. It doesn't even matter what the final court has to say. Again, if I'm Donald Trump's lawyers, I go through that process, but you go to the Supreme Court of the United States. Now, how do we get to the Supreme Court of the United States? This is where people get bogged down. There are writs at common law. And it really doesn't matter which writ you follow. Here's a piece by former Attorney General Griffin Bell. He would later become Attorney General under Jimmy Carter. In the Southern Methodist University Law School Law Review, the federal appellate courts and all writs. And it discusses what these common law writs are. Now, it discusses it in the context of a specific statute, the All Writs Act, that was passed as part of the original Judiciary Act in 1789. Not to get into the weeds, we're smart, we can follow this. The peremptory common law writs are among the most potent weapons in the judicial arsenal. These common law writs are used, they're rare, but they're used more and more within the federal chain of courts.
Warning, don't believe.
What does he say here? Well, the basis for general judicial supervision over inferior courts, inferior federal courts, through extraordinary or preemptory writs can be found in early common law. The All Writs Act is a direct descendant of the Judiciary Act of 1789, other than the Supreme Court, which is created by the Constitution. Everything else is created by Congress. All the other courts, the number of courts, how many justices are on the Supreme Court. It granted federal courts the power to issue extraordinary writs in aid of their respective jurisdictions.
So Mark Levin is explaining, ladies and gentlemen, how it gets to the Supreme Court. It's very important. Very, very, very important, ladies and gentlemen. And this is something that there might be a situation which I'm giving like 5-10% chance to, where Trump and the state of New York play chicken, and an actual jail sentence. They want him in jail. They want the man in jail. And they want that photo. And Trump might not care. I don't want him in jail. I think that you have Democrats actually committing crimes, and then you have Trump, who is facing jail for something he didn't do, which is typical of American politics. But that's the only... Okay, the Supreme Court might say, well, you know, there hasn't been a sentencing yet. They wait for the sentence. The sentence is jail. They tell Trump, you're going to go to jail immediately. The Supreme Court then gets involved, overturns the case, and there's a 1% chance that they try desperately not to let him out of jail for some peculiar reason. They'll say, "Oh well, it was and then he had a firearm in Florida. Who knows?" He cannot step foot in that jail. I don't want him to, because he didn't commit a crime. The same Democrats who care so much about prison reform, which, by the way, Trump passed and Biden's crime bill was the antithesis of, they want him in jail for something he didn't do. These are the wonderful, morally superior liberal Democrats who hyperventilate about authoritarianism.
And while it is clear that the All Writs Act authorizes the issuance of the traditional common law writs of mandamus and prohibitions, the phrase all writs also encompasses common law certiorari, injunctions, subpoenas. Don't worry about all that. What that really means is there's many ways of characterizing this direct appeal to the Supreme Court and relaying the facts and relaying what's taken place under the law to the court. In fact, you can use multiple requests for writs. It says choosing the correct writ to obtain the desired relief is no longer necessary in the federal courts. Different writs may be sought alternatively or cumulatively. The choice is now unimportant. The subtle distinctions among the various writs have no effect on their relative usefulness as vehicles for interlocutory review. We're not seeking interlocutory review at the federal level, but in effect we are of the state court's activities. Hello, before you finish on the state side, we have some big questions that the Supreme Court needs to answer. The jurisdictional prerequisite for application of the All Writs Act is simply that the writ be necessary, appropriate, in aid of the jurisdiction of the issuing court. The Supreme Court in Labai versus Howes-Letber Company explained the power of the courts of appeals under the Act. Quote, "The question of naked power has long been settled by this court. Since the Court of Appeals could, at some stage of the proceedings, entertain appeals in these cases, it is power in proper circumstances to issue writs of mandamus reaching them. This is an expression of prospective or concurrent appellate jurisdiction. The power of the courts of appeals to issue writs is not limited to cases where an appeal has already been filed. Rather, this power of review extends to all proceedings where the actions of the trial judge at some future stage of the litigation may be reviewable." That applies to the federal chain. But as I explained here, we have violations of federal law, of federal constitutional provisions by a state court.
There were obvious violations by the state court, and that's the point. That's the point. It's like this is so blatantly unconstitutional, and I'm going to continue to try to tell the world this. This is pretty obvious. I don't think most people understand, whether you like Trump or you don't like Trump, that this is so overtly and blatantly unconstitutional. This is worse than the Colorado ban, where even liberal justices, I think you're going to get one or two or all of the liberal justices siding to overturn this absurd, because this can be used against Democrats. There's a bunch of federal statutes that state courts could level against Hunter, Biden, Clinton, and others without the federal government being involved. If you want to play that game, red state, city, and state, a conservative, Trump-supporting red state levels federal laws against Democrats who happen to do business for a second in that state or happen to live in that state for a second. So it's like, you can do that if you want to, but then you've opened up a Pandora's box where you'll find a lot more Democrats who are actually convicted of specific crimes. So with Trump, they tried desperately, absolutely, oh my God, they tried so hard to fabricate a felony from misdemeanors. With Hunter and Joe, you have obvious graft and bribery almost certainly within a laptop. By the way, could you imagine if Donald Trump had a laptop flip the script. When Democrats are used to living in a world where they get the media to foment their nonsense. But imagine if you flip the script. Just flip the script. Have Trump with a laptop.
Now, does the Supreme Court, does the federal government ever get involved in state court decisions or state law decisions or state regulatory decisions? You better believe it. There are things called express federal preemption, which is what we have here. Federal Constitution, federal due process rights, federal equal protection rights under the Constitution as applies to the states. Federal jurisdiction under the federal election law, under a federal presidential election, and I could go on and on and on. You have implied federal preemption. You have states that are obstructing federal preemption. You have all this litigation and precedential activity that's taken place before that gives the Supreme Court jurisdiction. A state cannot regulate Congress, which is what it's doing in that court when it takes over authority for determining what a federal election violation is.
Let's listen to that again. This is gold.
That gives the Supreme Court jurisdiction. A state cannot regulate Congress, which is what it's doing in that court when it takes over authority for determining what a federal election violation is. That's important. Or the Equal Protection Clause, or the Due Process Clause, or the First Amendment Free Speech Clause about a non-disclosure agreement. Federal courts, starting with the Supreme Court, have intervened in state actions before. Civil rights issues, death penalty issues, Bush versus Gore, a presidential election issue, where you have federal jurisdiction issues. And how have they used it? Well, the Supremacy Clause, they've used the Commerce Clause, they've used the Necessary and Proper Clause. When it comes to regulating federal elections, especially a presidential election, Congress has exclusive plenary power. And the Supreme Court has overall authority. When you have an extraordinary, radical, extreme, multitudinous case of violations of federal law, whether it's substantive, whether it's process, whether it's jurisdiction, this is the case. Me, as I said first out of the gate, I'd file common law writs. I'd file a writ of prohibition that restrains a body exercising public power from exceeding its powers or usurping jurisdiction, which it does not have. It seems like this.
It's obvious it does not have the jurisdiction. It does not have the authority to level a federal crime at Trump. The state of New York does not have the ability to do that, and they did that. It's unconstitutional.
You could file a writ of mandamus ordering a lower court, in this case, the state courts, to stay their actions while the court considers it. It might go with a writ of certiorari, arguing that there is a statutory basis for it. It doesn't matter. You've got to take it to the door of the Supreme Court. They will decide whether to take it or not.
This is John Yoo, former Attorney General, also talking about this and talking about how it's unconstitutional. This is the biggest story, ladies and gentlemen. People are talking about it. It's all over. This is Vanity Fair. Trump is looking for a little help from his friends on the Supreme Court. They know what's taking place. Whenever you have Vanity Fair or Vox or other publications suddenly talking about the Supreme Court and Trump, they did this immediately before the overturning of the Colorado ban. This is essentially a done deal. Now it's just a matter of when the Supreme Court gets it. It's so blatantly unconstitutional.
It's hard to exaggerate the harm that it's going to do, not just to Donald Trump. He's important, but the more important question is, what does this do to our institutions? As you said, our legal system, our electoral system, our system of federalism and the separation of powers for all future presidents, for all future citizens. First, we have never prosecuted a former president before. This was not because past presidents hadn't done anything bad. It's because we thought it was the best thing for our separation of powers to leave presidents alone. And the reason why is because the Constitution concentrates so much responsibility and authority in the president to take care that the laws are faithfully executed, to protect the country from foreign threats, that we don't want our presidents, when they're making the hardest decisions on behalf of the country, to be worrying about whether they're going to be prosecuted or not. We don't want our presidents to be insurance claims adjusters worrying about risks and balances of their own personal finances and their own personal legal situation. We want them to decide what's best for the country. Now, because this case was so frivolous, because it was based on such concocted legal theories, it opens the door wide now for any DA, and there are 2,500 of them in the country, any DA to sue and prosecute any president, any past president, perhaps any sitting president under the theories that were put forward earlier. I think an even worse problem is for the rule of law. Because what we've all learned now, I think, is that prosecutors can destroy a person. They can destroy a person's reputation, his finances, just by investigating them, even before they get to court, just by publicly announcing that they're investigating someone.
By the way, the Clinton Foundation had like a 2-second investigation in New York in 2016. Found nothing, of course. Uranium deal, arms deals, Haiti, found nothing.
We have for 230 years relied on prosecutors, on our elected chief executives, governors, and presidents to show against statesmanship, to go show good judgment, not to abuse this power. But now what we've seen is that I think the Biden Justice Department and these blue city DAs are abusing this power, not to try to stop crime, but to target individuals because they don't like them, because they're unpopular, and then to find the crimes to fit the man. That is directly a direct assault on the rule of law. And that harms all of us in the country, all the citizens, not just Trump, not just presidents, but you and me and everyone else.
And what about the electoral system when you have one of these DAs deciding that they get to decide or try to decide the outcome of an election through the process? They can make a ambiguous reference to federal law, seize jurisdiction from what is a complex layer of federal authorities and decision makers when it comes to federal election campaign law, let alone seize the authority from federal courts and the Supreme Court to make these decisions, regardless of what the New York courts say up and down the chain. I mean, whatever the New York courts say up and down the chain, that is not the final decision. If the federal Supreme Court decides to step in, that's the final decision for you, New York. So if I'm in California and I see that it worked in New York because we have this lumbering appellate process, but I can interfere with an election, by the time the appellate process catches up with me, so be it. They're going to time it the same way. So this can really become a cancer on the political campaign system of the highest federal official in the United States. And the election there too, no?
Mark, I appreciate what you said in your opening statement, because the Supreme Court has made clear, not just in one offside comment, in 3 very clear decisions, that only the federal government can enforce federal law. Only the Justice Department and the Federal Election Commission can prosecute and bring suit for violations of federal election law. They're the guardians of how federal election should run. And so what happened here is that the DA, approved by this judge, Judge Merchan, grabbed the authority away and basically decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism, and the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
So, ladies and gentlemen, it's all over now. The news, different publications talking about Trump and his conviction being overturned. It's essentially already happened. In my book, it's essentially already happened. The Colorado case is even, like, that isn't even as egregious as this, and it was a 9-0 unanimous. I think you're going to get a unanimous Supreme Court, definitely at least 6 or 7-2, overturning Trump's conviction. It's just a matter of when they get it. Hit subscribe to this channel, ladies and gentlemen. I will have a live stream probably around 1 p.m. Eastern tomorrow. Hit subscribe, everybody. It's a done deal. It's just a matter of when it happens. Hopefully before sentencing. They might have to wait for sentencing, but the Supreme Court essentially is already